1. Report to the Electoral Commission. Scope of this report. 1. At the request of the Chair of the Electoral Commission, EC, on behalf of the Board of the EC, I am reporting on the facts surrounding the consideration by the EC of the application by a political party registered as Britain First, the party, to register a member Lee Rigby as a description of the party. 2. The scope of the investigation covers when and how the decision to register the party description Remember Lee Rigby was taken, the decision, which EC staff knew of the decision, and when did they learn of it, whether the EC processes were correctly followed, what considerations were taken into account and informed the decision, how that decision, and the reasons for it, were recorded and communicated, what caused the EC to realize the decision was wrong, and when, how the EC acted when they realized the decision was wrong. 3. This report was required to conclude on whether the EC exercised its responsibilities properly in this matter, and whether the actions taken since are sufficient, and to make recommendations on any and all actions that the EC should now take in order to address the findings of the report. Background. The EC legal duty and statutory tests. 4. The EC functions under the Political Parties, Elections and Referendums Act, PARA, and its role includes registering political parties and party descriptions and emblems for use on ballot papers. A party can register up to 12 descriptions and 3 emblems. 5. PARA only permits refusal to register a party name, description or emblem if it is the same as, or is likely to result in electors confusing it with one that is already on the register. It is obscene or offensive, or includes a prohibited word, or its publication would likely amount to an offense for reasons unconnected with PARA, or if appearing on a ballot paper it would be likely to result in electors being misled as to the effect of their vote, or to contradict or hinder an elector's understanding of any directions for voting on the ballot paper or elsewhere. 6. PARA also maintains a list of prohibited words that can only be used under certain circumstances. 7. The Register of Political Parties. The register, administered by the EC's Party and Election Finance, PEF, Directorate has admitted more than 900 political parties since 2001. There, too, are currently 372 registered in Great Britain and Northern Ireland. On average around 50 new parties register annually, although this can increase significantly around an election. 8. The register is used as the principal point of reference by those charged with the administration of elections. The only names and descriptions permitted on a ballot paper are those on the register. Investigation. 9 interviews were conducted with relevant members of staff on Tuesday 29 and Wednesday, the 30th of April. I was given full cooperation by all members of the EC staff and was impressed by their lack of defensiveness and their openness. 10. The interviews were structured to cover the EC process, the actual decision, the identification of the problem, actions taken, improvements to procedures, any other points relevant to the investigation. 11 notes were taken at all interviews and interviewees were given the opportunity to check these for factual accuracy. Original decision-making process. 12. Britain First made an application online for registration together with 7 descriptions. The People's Party. British Jobs for British Workers. Putting British People First. Say No to EU. Remember Lee Rigby. Vote British. Defending the Union 2014. 13. A policy advisor, a relatively junior member of the PEF team, was responsible for applying the standard internal tests and ensuring that all documentation was complete. 14. The EC has a comprehensive document setting out the processes needed to register names, descriptions and emblems and the procedures required of staff before making a decision. This known as the Quality Management System, or more usually QMS. My review of QMS is that it is clear, comprehensive and regularly reviewed and updated. The last update was dated the 28th of May, 2013. The policy advisor in this case was familiar with the QMS and had written sections of it. In addition, the EC has 3 standard documents: an approval record for party registration, an approval record for party descriptions, and an approval record for party emblems, 34 pages in total. These documents are intended to guide the policy advisor through each of the requirements of PERA. Each test requires an active decision, yes/no, and a signature, and has space for reasons and director's comments against each test. 3. 15. From my review of the documents in this case, I noted that one box was not signed regarding whether the financial scheme complied with PERA Section 26. The policy advisor appeared unconcerned as he believed that he had received a compliant scheme. I was also advised by EC legal counsel that the application form was flawed in that a business address was used on the application rather than a home address for the party leader, treasurer or nominating officer. In all other respects the approval records were complete, although where a yes answer was given the reasons box was left blank. 16. In applying the standard internal tests, the policy advisor used the PEF online system to test each word in the party name or description. PEF Online is the IT system used by the EC to administer party and election finance. In this instance it is used as a database to search for names and words which may indicate a breach of PERA requirements. 17. The policy advisor's checking revealed the following: returned words, no result words. Britain Lee. First Rigby. British Union. Jobs 2014. Workers. Putting. People. Say. EU. Remember. Vote. Defending. 18. This result then triggered further consideration of the returned words to establish if the PERA rules would be contravened. Using the PEF system, it was then possible to identify other parties using these words and apply the PERA tests. 19. Narrative on the approval records shows it was considered that Description 1 was the same as a description registered by the Independent Labour Group and must be refused. Description 2 was the same as a description registered by the British National Party and must be refused. Description 3 was considered to be a description would be likely to result in voters confusing the party with the South Tyneside Independent Group / People First Party, which have registered putting people first. Description 4 would be likely to result in voters confusing the party with the No to EU party. 4. 20. The other descriptions were documented as acceptable against all other criteria, i.e., no more than 6 words. Not obscene or offensive. Unlikely to amount to the commission of an offense. Does not include any script other than Roman. Does not include any word or expression prohibited by order by the Secretary of State. 21. The overall quality of the approval records was good, and the reasons for refusal of the first 4 descriptions were clearly stated. Unfortunately, where a description was accepted, there was no narrative to explain the rationale at the time. 22. The documentation was passed to the Director of PEF. He recalls discussing the application and approving the registration of name and 3 descriptions, remember Lee Rigby, Vote British, and defending the Union 2014. The date on the document was the 7th of January, 2014. 23. The registration was then entered on the register and the party notified in writing of the registration of party name and 3 descriptions, together with the reasons for rejecting the other 4 descriptions. I have identified no other Commission staff who were informed or aware of the decision. This is normal practice for the 50+ party and 400+ description registrations applied for annually. 24. Having reviewed the internal QMS documentation, I am satisfied that the staff believed they had followed the internal process. The defects in the application noted above were not seen as significant. However, I believe that the decision-making in this case was fundamentally flawed, in so much as the staff I interviewed were of the opinion that the legislative framework required them to register party names and descriptions unless there were compelling reasons not to do so, and did not give sufficient thought to the overriding need to consider context when making decisions. Consideration of offensiveness. 25. PERA does not define the term offensive, and the EC is required to interpret what was intended by the authors of the Act. It is evident that the EC has previously expended considerable time and resources in defining each of the criteria, in particular whether descriptions are confusing. Several of the staff interviewed talked of the constant challenge to balance freedom of speech with the need for the voter to understand the ballot paper. 26. There have been 2 recent discussions on registration at EC board meetings, and from my review of the minutes it is clear the primary concern was avoiding the risk of misleading the voter. EC has received very few applications that were deemed offensive. The examples shared with me were generally racist and / or actively derogatory about an ethnic group. 27. Where such applications were received in the past, legal advice was sought, and if an applicant is refused, the reasons are set out in writing. I have reviewed several examples of such legal advice, and each has set out in detail how a decision should be made, but in each case has stressed the need to balance rights of the voters against freedom of speech. 28. I have also reviewed a document called How to Approach the Question of Whether a proposed party name or description is offensive for the purposes of Section 5. 28, 4c, or 2802c, PERA. This was prepared by the EC legal team to guide staff. A version of this was previously sent to the policy advisor in relation to another party name and description application. Given the significance of this advice, it is reproduced here in full. 1. The Commission should consider the matter carefully and take into account all relevant factors, and disregard all irrelevant factors. The Commission should ensure that its final decision is reasonable. There may be a range of reasonable decisions in any case. A court is unlikely to seek to substitute our judgment with its own of what is offensive. Rather, it would look to test whether any decision by the Commission is reasonable. Accordingly, a court is unlikely to Find a Commission decision within the reasonableness range as unlawful. 2. There is no special legal meaning of offensive either in electoral law or other relevant legal contexts. Therefore, offensive should be given its natural meaning. 3. The Commission should take into account any contextual factors that may affect whether or not the name or description is offensive. This includes but is not limited to considerations as to connotations of the proposed name or description in the light of socials, mores and public policy. 4. The Commission must only look at whether the name or description is offensive, not any other aspect of the party, for example its policies. However, the party's policies may form part of a relevant context that affect whether the name or description is offensive and, if so, should be taken into account. 5. The test is whether the name or description is offensive. This should not be confused with whether the name or description is the view of a minority or whether the name is controversial or unpopular. 6. What is offensive has to be judged by considering the reaction of reasonable people who are neither hypersensitive nor insensitive and by the standards of an open and just multiracial society. 7. The test for whether a proposed name or description is offensive is a high one. It should be considered to be particularly offensive for the Commission to decide that the party's application for registration should be refused. 1. 8. Could the name or description be considered to be political expression? This is interpreted to be anything that discusses a matter that is political in nature or is of public interest. If so, the risk of a successful legal challenge for breaching the ECHR is increased as such expression receives higher protection. 9. Additional protection is also afforded under the ECHR to comments made in election campaigns. As a party's name or description is a key part of election communications, this increases the risk of any decision to refuse to register a name or description being challenged for breaching the ECHR. 10. Does the name or description criticize politicians, governments or other powerful organizations? If so, any decision to refuse to register it would be subject to an increased risk of successful legal challenge as such expression is highly protected by the courts. 11. If minded to refuse to register a party, or a description, on account of party's name, or the description, being offensive, the Commission should consider whether doing so would be justified under Article 10(2) ECHR. For example, is the decision necessary to protect public safety, morals or the rights/reputations of others? 12. If the Commission were to decide that a name or description was offensive and that the language used was highly insulting to particular racial or ethnic groups or that the language used incites violence or spreads hatred, there may be a strong argument that the restriction of the Article 10(1) ECHR right to freedom of expression by refusing to register the party is justified under Article 10(2), because of the need to protect public safety, morals or the rights/reputations of others. Refusing to register such a name under Section 28(4) c. para on account of it being offensive may be justified under Article 10(2), even if it constituted political expression. 1. This is because Article 10(1) ECHR protects the right to freedom of expression and UK legislation must be read in such a way as to comply with the ECHR. Case law on similar provisions, for example Section 1 Malicious Communications Act 1988, shows that courts are likely to use a heightened test of what is offensive in order to ensure ECHR compatibility. 6. 29. In addition to the above advice, the procedure document, QMS at paragraph 34.12 stated, offensive should be understood in a broad and natural sense and not in any artificial, narrow sense that would exclude cases in which the offensiveness of the name lay in that of the political ideas reflected or expressed in it. The approach includes considerations of connotations of the proposed name in the light of social mores and public policy. 30. In exploring the decision with the policy advisor and director of PEF, it is apparent that at the time of considering the decision neither understood that the phrase "Remember Lee Rigby" could be seen to be offensive. The director of PEF remembered thinking that it was distasteful but not sufficient to cause offense. It must be said that both members of staff now recognize the enormity of the offense caused to Fusilier Rigby's family. Neither recalled thinking of the impact on the family, but only of the impact on voters in general. 31. The director of PEF recalled thinking that whilst the description could have offended, it would not be sufficient offense to cause a voter not to vote, which was his test. He confirmed that he did not seek legal advice. 32. I believe that the two members of staff acted largely within the processes and procedures of the Electoral Commission. However, in making their decision to register Remember Lee Rigby, they failed to comply with paragraph 34.12 of the QMS and in so doing, failed to follow EC procedures in full. 33. By not referring to the need to take into account contextual factors, the director of PEF limited the scope of his deliberations. Further, had either member of staff referred to the guidance above, he would have seen a challenge is the decision necessary to protect public safety, morals or the rights forward/reputations of others, which, given the use of a person's name in the description, may have prompted him to consult more widely. 34. Whilst the approval record itself is of high standard, it would appear that the form drove the process, rather than the principles set out in the QMS. I believe the form was carefully considered, as evidenced by 4 descriptions being refused. However, there is no evidence to support the rationale for allowing Remember Lee Rigby and evidence that the EC procedures were completed in full. The fundamental weakness in what looks like a rigorous process is that there is no positive acceptance or consideration of a description. It is entirely a negative. Does it fail these tests, and if it does not fail it should be registered. 35. Having failed to recognize the application as a difficult decision, the opportunity to seek other opinions was lost. Further, as the admission to the register is not particularly noteworthy, it was improbable that the description would be picked up until it was used in a nomination. 36. It would appear that the director who made the decision took a very narrow view of what constituted offensive and, in failing to consider the context of the application, failed to comply with the expectations of the Commission or the requirements of para. 7. Part 2. Discovery of the decision. 37. What follows is my understanding of the chronology of events. Whilst I have used best endeavors to make this accurate, it has not been possible within the time constraints of this report to triangulate and confirm each stage. It will, however, provide an indication of the sequence of key events and the complexity of the situation. 38. The identification of the registration occurred through 2 different streams of events. Although the source of both streams originates in Wales. On the 23rd of April, the EC Wales office became aware that Britain First was seeking nomination in Wales, and this was noteworthy because nominations were due to close within 24 hours and last-minute nominations generate difficulties for returning officers with the printing of ballot papers. The head of the Wales office visited the Britain First website and considered that she should notify the Regional Returning Officer, RO, of her concerns that there could be public order issues if the party stood in the election. 39 at 16.46 on the 23rd of April, the head of the Wales office, who was not in the office, received confirmation from a colleague in the office that the party Britain First were registered. At this point she did not address the question of what description the party might use on the ballot paper. The head of the Wales office was concerned, as in any election, with the logistics of printing ballot papers by returning officers and also arranging a meeting for parties the next day. The head of the Wales office could not have known which description was going to be used, although she, or others, could have seen that "Remember Lee Rigby" was one of the three possible. With the benefit of hindsight, it would appear that this was the last point at which the registration of the party description could have been identified by anyone as a concern, and consideration be given whether it would be possible to prevent it being used on ballot papers in Wales. 40. The use by Britain First of the description "Remember Lee Rigby" crystallised when the party lodged its nomination papers with the Regional Returning Officer. Once the nominations closed, at 16.00 Thursday the 24th of April, the statement of parties and individual persons nominated was published, stating the name of the candidate, and the name and description of each party. This was sent to the Wales office of the EC on Thursday the 24th of April, 2014, at 18.16, but not seen until the next morning, when it was also shared with colleagues around the EC as a routine piece of pre-election communication. 41. On Friday the 25th of April at 9.56 an email was received from the office of the RO forwarding a complaint from the Socialist Labour Party about the use of the description. The head of the Wales office recalls shock at seeing the description, but was confident that because it had been registered it was permitted. She reported that on previous occasions she had seen descriptions that were near the knuckle but had accepted that they were within the law. The Wales office of the EC asked the PEF team for a response as to how to handle the complaint. Unfortunately, the request went to the same member of staff who had made the original recommendation, who did not see the need to escalate or rush a response. 42. As staff in the Wales office were concerned about meeting candidates later that day, and the potential for public disorder, they chased for a response and were given a standard reply at 12.45. The head of the Wales office was not satisfied with the response, so she called the EC communications team at 12.59 for a better response. 8:43 Meanwhile in London, at 9 a.m. the senior media and public affairs officer of the EC saw a tweet regarding the description and raised this with the head of media and public affairs. 44 The issue was escalated to the head of media and public affairs by mid-morning, and he sought to establish the relevant facts from staff in PEF, including the director of PEF. When he received answers that suggested to him there was a significant problem, he escalated it to the Director of Communications, who was told about the description shortly after 12:30 p.m. The Director of Communications and head of Media and Public Affairs agreed the need to establish a way of contacting the family. For the EC to apologize to them, followed by an EC public apology, and to involve other senior staff. 45 by 1:15 p.m. The Director of Communications had discussed the matter with the Director PEF. They agreed to convene a wider meeting of senior staff to decide on next steps. 46 at 13:30 p.m. A conference was held by the Directors PEF and of Communications, Legal Counsel, Head of Electoral Policy and the Head of Media and Public Affairs. It was agreed that, in view of the seriousness of the matter, the Chair and Chief Executive must be contacted for an immediate highest-level review. To inform this, between 2 p.m. and 3:30 p.m., a series of actions the EC would need to take was considered, given the position in electoral law that the description would be on ballot papers. 47 at 15:30 p.m. There was a teleconference involving Chair, Chief Executive, Directors of PEF, Electoral Administration and of Communications, Legal Counsel, Head of Media and Public Affairs. It was apparent to all participating that the family of Fusilier Rigby were likely to be offended, as the Chair had recalled seeing a press article that had referred to the family not wanting his name used for political purposes. Consideration was also given to the likelihood of members of the armed forces being offended seeing a colleague's name being associated with a political party. 48 A number of immediate actions followed, primarily tracking down and making contact with Fusilier Rigby's family, seeking legal advice on how to remedy the situation, and preparing an apology. This took until late on Friday evening. 49 On Saturday the 26th of April the last members of Fusilier Rigby's family were contacted and spoken to. By late morning the following had occurred. EC apology statement issued. Press Association notified. Conversations held with senior civil servants in Cabinet Office. Discussion between the Chair and the Chairman of the Speaker's Subcommittee on the Electoral Commission. Teleconferences / ongoing discussions between senior Commission staff and with the Chair. Liaison between Cabinet Office officials and Commission staff, including on possibility of changing the law. Discussions with Regional Returning Officer in Wales. Discussions by the Chair with the Minister, mid-afternoon. EC Board briefed, early evening. 50 Sunday the 27th of April the following action was taken. 9. EC Board meeting held during morning. Liaison between Cabinet Office officials and Commission staff, including draft statutory instrument to change the law worked on. Discussions with Regional Returning Officer in Wales. Legal Counsel led drafting of terms of reference for independent investigation. Discussions by Chair with Speaker of the House of Commons. Teleconferences / ongoing discussions between senior Commission staff and with the Chair. Independent Chair of the Audit Committee asked to lead investigation. 51 By Monday the 28th of April. Agreement of investigation terms of reference. Discussions with Regional Returning Officer in Wales. Liaison between Cabinet Office officials and Commission staff, including draft statutory instrument to change the law worked on. Legal Counsel drafting of Commission legal decision letter to remove the party. Description from the Register. 52 By Tuesday the 29th of April. Discussions with Regional Returning Officer in Wales. Liaison between Cabinet Office officials and Commission staff. Advice being taken from a QC on the draft Commission decision letter to remove the Party description from the register. Independent investigation commenced. 53. Reviewing the timelines, it is clear to me that, having missed an opportunity to identify a problem in January, the earliest time that any EC staff could reasonably have identified the problem was at 18.16 on Thursday the 24th of April. As it was, the statement of nominated persons, the tweet and the email of complaint from the Socialist Labour Party were all seen on Friday morning. 54. By 10 a.m. there were potentially 14 staff. This is an estimate based only on circulation lists on emails, who were aware of the registration and either foresaw the possibility of disturbances at the election in Wales or the possibility that there had been a description registered that would lead to criticism. 55. It has been difficult to establish the precise moment when a reasonably routine matter was recognized as a major problem. It would appear to be mid-morning, but accounts differ. It is clear that by 13.30, EC staff at the London office were aware that they had a serious problem. Their priority at this stage appeared to be ascertaining facts, preparing a pro-active press statement and identifying ways to contact the family as fast as possible if a decision was taken to apologize. It was not until 14.00 that staff attempted to contact the chair or chief executive, who were both off-site, but contactable. The delay in escalating the issue cost the EC several hours, which was all the more relevant as events unfolded on a Friday. 56. Prior to the chair's input, it was apparent that effort was made to test the legal position, prepare lines of defense and to line up options for consideration. It is clear that the chair immediately made it very explicit that the EC position was to first consider the needs of the 10 family of Fusilier Rigby, to apologize publicly and quickly and then to seek to mitigate the damage done. 57. As soon as the family were identified as the EC's first priority, strenuous efforts were made to make contact with the family. This involved many telephone conversations with MOD personnel, several police authorities, and several family liaison officers, all of whom expected to speak directly to the chair before the relevant telephone numbers could be obtained. It is clear that all staff believed this to be the most important task, so that an apology could be made to the family in advance of any newspaper coverage. The chair made each call personally, during Friday evening and Saturday morning. These were difficult and emotional calls, and I commend the chair for taking full responsibility for this role and not delegating. It should be noted that each call confirmed that the use of Fusilier Rigby's name in a party description had caused deep offense and distress. 58. Such was the challenge of the first step. It is possible that other stakeholders were not necessarily briefed as early as they may have hoped to have been. It may have been that some calls could have been made sooner by other staff, notwithstanding the usual convention of the chair making such a call. Subsequent actions. 59. Having spoken with all family members, attention switched to looking at options to remedy the situations. Legal advice was that once nominations closed, the ballot papers could not be altered. If this was to be achieved, legislation would be needed, and although this was not within the gift of the EC team worked with other stakeholders to establish whether this would be possible. It is beyond the scope of the report to comment further on this, but I note that significant efforts were made to find a way to remove the description from ballot papers in Wales for the 22nd of May election. 60 When it became clear that changing the ballot papers for the European election was unlikely, the EC made a very public apology. The apology was made over the weekend. Where potentially there would be little media coverage, it is commendable that EC contacted the Press Association to ensure that the apology was given greater prominence. 61 In the days following, the EC responded to the needs of many stakeholders and has established the legal means to prevent the description being used again. 62 It is the view of the EC that failure to consider various matters in making its decision renders the decision defective in public law terms and leads to the conclusion that the registration of the description is null and void and that the entry will be removed from the register. 63 The EC has commissioned this independent review, which will be shared with the Speaker's Committee and published. 64 In summary, events unfolded over a very short period of time, and it is regrettable that staff lost time on Friday the 25th of April, as this added to the pressure felt by staff on Friday evening, made liaison with other organizations difficult and reduced the time available to other colleagues. Once the EC recognized that they were dealing with a major problem and escalated the issue to the Chair and Chief Executive, all resources of the EC were focused on mitigating the impact of what they recognized was an incorrect decision to register a party description that would cause offense. I have found no evidence of attempts to cover 11 up or dismiss the problem. The Chair faced up to her responsibilities and acted swiftly to take control of the situation. It is perhaps too early to judge whether the EC's actions were sufficient, however I can suggest nothing else that I believe could have been done. Recommendations. 65 All future decisions concerning the registration of party names, descriptions and emblems should include a broader consideration of context, as set out in legal advice of the 28th of March 2013 and the QMS, and this should be documented on the approvals records. I would recommend the use of an internet search engine. 66 All future decisions concerning the registration of party names, descriptions and emblems should be considered by a wider group of senior individuals. It is for the Commission to decide who, but I would suggest it includes individuals with experience in elections, law and communications, to obtain as wide a perspective as possible. 67 Consideration should be given to defining, more clearly and publicly, the criteria used by the Commission in deciding on registrations. This process would benefit from wide consultation. 68 Where personal names are used in names or descriptions, I recommend that the person's consent, or that of the family, is always obtained by the party making the application. 69 The Commission should instruct their internal auditors to ensure that all names and descriptions on the register comply with the requirements of PRA, reflecting the legal advice, both to test that procedures were followed and that there are no other descriptions which would have the potential to cause offense. 70 Given the delay in escalating concerns to the Chair and Chief Executive, and the concerns expressed to me about a lack of structure in the early hours of the incident developing, particularly when the Chair was so fully engaged with making contact with Fusilier Rigby's family, the EC should review its crisis management policy and have a lessons learned session with all interested parties at the earliest opportunity. Conclusion. 71 In allowing a party to register with a description which has caused offense to the family of Fusilier Lee Rigby, and potentially many others, the EC has failed to exercise its responsibility properly in this area. 72. Whilst the decision-making process is well documented, auditable and was in this case largely complied with, the subjective nature of the decisions made by a limited number of staff with limited internal review, this leaves the EC exposed to an ongoing risk of registering a description that is contrary to the requirements of para. 73. The EC has, in the past, determined that certain descriptions were offensive, and has obtained clear legal advice that context is important in making a decision. It is regrettable that the broader context consideration recommended in March 2013 and required by the EC's QMS was not followed by the policy advisor and director of PEF in the decision-making process in this case. 12. 74. I am of the opinion that had the policies and processes of the EC been followed in full when the decision was made, it is less likely that an incorrect registration would have occurred. Had the director of PEF taken advantage of the experience and expertise available to him outside of his directorate, he may have reached a different conclusion, although this is impossible to prove. The director resigned on the 1st of May 2014. 75. As soon as the registration was recognized as a problem, the EC acted promptly. From identification of a problem during the morning of Friday the 25th of April, staff worked throughout the weekend to mitigate the effects of the use of the description. However, it would appear that several hours were not used as best as they could have been, before the chair and chief executive were notified. 76. The EC's first concern was to contact the family and apologize, then to notify other stakeholders. This was of necessity a slow process, and it could be argued that someone other than the chair could have made some of these calls. However, it would appear that all key stakeholders or their offices were contacted relatively rapidly and ready assistance offered. 77. In terms of subsequent actions, the EC have issued a full and unequivocal apology, including ensuring that it received wide media coverage, and the EC has commissioned this independent investigation with which all staff have cooperated fully. The EC has received advice that the registration is null and void and will remove the description from the register and will not, in future, be used. The chair of the EC has accepted full responsibility for the actions of the EC, has personally undertaken the most difficult of conversations and, on the 29th of April offered her resignation, which was declined, pending completion of the report. 78. It is regrettable that, despite the efforts of many people, it will not be possible to amend the ballot papers for the European election and that as a result the number of people who may be offended will increase substantially between now and polling day. However, I am of the opinion that the EC has worked to mitigate the impact of what they agree was an erroneous registration of the description. Remember Lee Rigby. 79. I would like to place on record my appreciation of the openness and cooperation of all Electoral Commission staff, and in particular their willingness to assist me with this investigation. Elizabeth Butler FCA. Independent Chair. Audit Committee of the Electoral Commission. The 5th of May, 2014.